What will we call the matters of the state of Michigan versus Damon Camp Krager, case number 22S00097, as well as 22T00300?
Rachel McDuffie for the people.
Paul Barnett on behalf of the township.
Assistant Public Defender Allison Muller here on behalf of Damon Camp Krager.
Sir,
Mr.
please state again.
Damon Camp Krager.
Thank you. All right. Did you have an opportunity to speak to your client about the bond violation?
I did, Your Honor. He will be admitting to the bond violation at this time.
Please raise your right hand to be sworn. Sir, do you swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. And you may lower your hand. Is it true, sir, that you tested positive for THC and on each test since December the 14th, which was 1, 2, 3, 4, 5, 6, 7, 8 tests?
Yes, ma'am.
And there was an abnormal creatinine on January 9th, correct?
What was that? I apologize.
There was an abnormal creatinine on January 29th.
What does that mean?
That there was something that showed up in your system that shows that your creatinine levels were abnormal, meaning that maybe you drank a lot of water or something occurred to make your creatinine high.
Creatine?
Yes.
Oh, I take creatine as a supplement.
So my question is, sir, are you acknowledging that you had an abnormal creatine on that date?
Creatine? Yeah. I did. Yeah. I consume creatine as a supplement.
I heard you say that the first time. I'm not asking you that. My question was simply, do you acknowledge that it showed up high or abnormal on that date?
Yeah, I didn't realize that we even tested for creatine. I apologize.
Do you find that there's a knowing and willing admission, Ms. McDuffie?
Your Honor, I think I do, but I just want to clarify. Mr. Camp Krager, creatinine is the substance that was detected. Creatine is a different thing. So creatinine is the substance found in the kidneys. So I don't want him to be admitting to something different than.
Yeah, I was confused. I apologize.
Just to be clear.
Yeah, I said I take creatine, not creatine. I don't know what creatine is. I apologize.
As I just said, abnormal creatinine shows that you were essentially consuming a lot of water. That happens when people sometimes try to mask substances in their system. So that is the result. Are you admitting to that as well?
No, I wasn't trying to mask substance. No.
And Mr. Kim, sorry, Ms. McDuffie, if I could for just a moment, we can explain why that might have occurred after. This is what you would be admitting to is just that the test results did show this on this one test date that there was an abnormal amount. You're not saying as to why that may have happened, is my understanding. You can correct me if I'm wrong. You're just saying that that test did show that. After you would say that, I think you've told me enough that I might be able to explain why that had happened.
Okay. Yeah, I'm sorry. I misheard you. I didn't realize what you were saying, what she was saying. I didn't mean to have that reaction.
Thank you.
So he is admitting to everything the judge listed.
Is that correct?
So as I'm reading it, first of all, I think I'm Googling it because I'm not an expert in this, but taking creatine supplements may increase the creatine levels. So it is possible that that is what caused it, just so that we're all on the same page. But they're pronounced differently because one is the levels and the other one is the substance. Okay.
Yeah, I apologize. I didn't understand.
All right. So in any event, are we satisfied now, Ms. McDuffie?
Yes, Your Honor.
Ms. Muller, are you satisfied?
I am, Your Honor.
Thank you. All right. So first of all, why is your client continuing to use THC when he's ordered to not do so?
Your Honor, I spoke with him about that. His understanding, I guess, and probably maybe incorrectly, was that after his arraignment, at that time he said it was flagged to him from the magistrate that if he were to get he had a medical card at the time, it expired. I don't know if that expired after the arraignment or it was already expired before. His understanding is that if he got that renewed, he would be allowed to use. And then he said at his last pretrial, I'm not sure, I wasn't there for that pretrial. He said that I believe it'd be Ms. McDuffie expressed her concern was mostly about the alcohol. So he still believed, okay, if I get my medical card, which he's in the process of doing now, he's got to submit the payment. So I'm not sure, I can't explain, Your Honor, why he used without getting the medical card renewed. I guess his understanding from the last pretrial was that it wasn't the concern. And so he took that to mean, okay, that's not the problem. I can continue using. It's the main concern is alcohol. So that was his understanding. I let him know we'd have to ask today if the court would allow, if he gets that renewed and submits proof of that renewed medical card, if he can continue to use, but he's not allowed to use definitely without it. So that is the information he provided me about the marijuana use. And I can also speak to the creatine now at this time too.
Right. I'm satisfied. Mr. Kemp Krager, I'm gonna be very clear with you. You cannot use marijuana until the court gives you permission to do so. I'm pretty sure I said this last time. If you test again, it should be going down. I don't know why you've just been continuing to use. I don't get that. So you know that you can have your bond revoked and you can go to jail, correct?
I understand, Your Honor.
All right.
Your Honor, could I just ask if he does get that medical card renewed and I submit proof of that, is that something the court would address later, or is that something the court would
address it at the time that I receive it? I determine whether or not I find that there's a medical necessity for it.
Okay, thank you, Your Honor.
As to the pretrials. Oh, wait, before we get there, Mr. Barnett, are you satisfied? I forgot to ask you, sir.
I am, Your Honor. Thank you.
All right. Now, as to the pretrials.
Thank you, Your Honor. We would like to set both pretrials for a final settlement conference.
Confirming for the record that Mr. Kemp Krager is rejecting the offer that he was extended. That offer was to plead to count 1 under 7694A, which is the first offender domestic violence program, with the dismissal of all the rest of the counts on the complaint, which are 2 through 3, and an agreement to repay $220 in restitution. So Mr. Kemp Krager fully understands what that first offender program includes, which is a non-public status and the case being completely dismissed from his record following probation. And he wishes to forego that. Is that correct?
Is that correct, Mr. Kemp Krager? You understand fully what the offer was and that you will be waiving that to set these matters for trial?
Yes.
Final settlement conference and both of these matters will be on March 28th, 2024 at 11 a.m. That is via Zoom. And then jury selection will be on April 5th, 2024 at 8:30 a.m. And that is in person at 8:30 a.m.
I apologize, Your Honor. Could you say that date one more time? My phone was skipping when you were talking.
April, both dates? What do you mean by that date?
Yeah, first date. I'm sorry. I apologize.
Final settlement conference is March 28th, 2024 at 11 a.m. on Zoom.
Thank you.
And then the jury selection is April the 5th, 2024 at 8:30 a.m. in person.
Okay.
This is
And
my warning about the THC search. Okay.
Yeah.
If I get a report that you violated again, then I'm going to issue a bench warrant.
okay, so they'll be able to see that the levels are decreasing though.
You should. Ms. McDuffie, you have something you want to say about that?
Well, I don't know that they will unless he specifically requests a confirmation test to get those levels, because we have had to do that in some other cases. They won't tell us what exactly the measurements are unless they pay for a confirmation test or whatever it is.
Thank you. So you may have to pay for confirmation tests. Okay, sir?
Do I just request that at the community corrections?
Correct.
Okay, thank you.
You're welcome.
So, I apologize, Your Honor. Just to be clear, so I am going to have a test this week, probably within the next 2 or 3 days. So that one is going to be positive. Should I request a confirmation test on that one, or should I just wait until the next test?
You should talk to them over there about what they plan to do if you're positive, if they're going to file a violation report or not. If they plan to file a violation report, then you should probably get a confirmation.
And Mr.
Okay.
Just one final thing, I would request definitely, because that can set the level going forward. It sounds like we don't have a confirmation test yet to compare to, so I would request that.
Okay, yeah, because that's my concern. Because I mean,
All right, Mr. Krieger, you're going to need to talk to your attorney separate. Okay, and if you guys need to go into a room, that's fine. But otherwise, we're going to move on with our docket.
Okay, have a good day, Your Honor.
Thank you. State of Michigan versus Riccobarde. What do we have to-
Can you hear me?
Yes, you're a little soft, but I can hear you. I don't know if you can turn your volume up any or not. Okay, let's go on the record, please.
Can you hear me?
It was better before.
Once. Hello?
Okay, now I hear you better there. Go ahead.
Okay. Yeah, what did you say?
That's much better. Thank you, sir. All right, we will go on the record now in the 13th Judicial District, the District Court of Greenwood County, Kansas. This is case number 2023 TR3 00060, State of Kansas versus Isaiah S. Curvin. This is a continuance of the hearing called earlier on the 9 o'clock docket. It is now 1:36 p.m. this February 5th, 2024. Coming on for a special setting. Now then, Jill Gillette, County Attorney, appears for the state, and the defendant, Isaiah Curvin, appears in person and pro se. This is the pretrial hearing. The trial is set for jury Wednesday and Thursday of this week. February 7 and 8, there is one count of operating a motor vehicle without a valid license. Now, that seems to the court to be you either had a license or you didn't. Of course, the burden would be on the state to show there was no license. But Mr. Curvin, are you challenging that? Are you saying you did have a valid license?
No, I had a question before all that about the jurisdiction. I was challenging jurisdiction because I had a question about that.
Okay.
I wanted to know the cause and nature of what's bringing the suit against you. I really didn't understand.
All right. Well, the people of Kansas, as you probably know, get together ever so often and have elections to elect people to represent them in Topeka, the state capital, and those legislators pass laws that are for the good of all of us in theory, maybe in practice, and then we are to follow those laws. One of the laws at some point in time that those legislators made was that if we are going to operate a motor vehicle in Kansas, we have to have a valid driver's license. And if you do not have a valid driver's license when driving the automobile, it is to be treated as a Class B non-person misdemeanor. And they set the penalties of up to 6 months in the county jail and a $1,000 fine. So the authority comes from the people of the state of Kansas that pass the laws through their elected representatives. And they also pass laws to have judges, and I'm one of those judges that presides over these type of cases. They also pass the law that you can't have a jury trial for this type of offense. And so that's the authority, that's the nature of it. It's a traffic case, but it's also designated a criminal case, a B misdemeanor. So does that help you with your question, sir, or is there something else we need to address?
Well, yes, I have another question. When you say it's been a criminal, would that it gives the court two ways? Sixth Amendment actually gives the court two ways to do it. They can do it through like either like common law or is it a colorable maritime admiralty law? Which one am I want to be tried under with jurisdiction?
This is neither common law nor admiralty law. This is criminal law under the Constitution of the state of Kansas, as affected by case law and federal law, of course.
So it's neither common nor color.
That is correct. That is correct.
So which one? What am I going to be tried under? What jurisdiction I fall under so I can properly move and so I can understand how to defend myself?
You're being tried under the criminal jurisdiction of the Kansas statutes.
But under the Constitution, it grants you only two, and it has two criminal matters. One has to be common law, the other has to be the maritime admiralty.
Ms. Gillette, do you wish to be heard in response? I'm sorry, I didn't mean to cut you out.
Judge, this is basically kind of more of a statutory violation. This defendant, when you enter into the state of Kansas, you consent to the laws of Kansas when you drive upon the highways. The interstate compact between all of the states that are members of the interstate compact for traffic infractions means that when you consent to the laws of your state or you drive upon or travel upon the roads of Kansas, Oklahoma, any of the states that are part of the compact, you consent to those laws when you enter into that state. So with the interstate compact, he would be consenting to the laws of the state of Kansas the moment he drives across the border. That law becomes effectual upon you, and it's your responsibility. It's akin as when you have a concealed carry. If you carry in Kansas and you have your concealed carry, it's your responsibility to know which receiving reciprocative of your concealed carry permit. If that state isn't reciprocative, then you cannot do it within that state. So when you become a licensed driver or you have a license or you become a driver and you're driving, then you are consenting to the laws of that state that you are traveling within. So jurisdiction is set up, as the judge said, by the Constitution of the state of Kansas and the laws of the legislature that are passed statutorily. And our statutes are passed with the law in this case. I would note for the record, Judge, that there is still no things on Odyssey for me to see. There's not a written request for jury trial. There's no motions to be heard today. I cannot respond to any motions because there's none on file.
Well,
therefore,
if
he is going to file anything of record for me to respond to, he would need to have his filings on file at least 7 days advance of a hearing for me to respond, and that there is no proper written request for a jury trial at this time. Therefore, this case could go to bench trial on Wednesday, and we would not have to have a jury present due to the fact that there is a lack of request for jury trial. And if there is no written request for jury trial, the case goes to bench trial.
Ms. Gillette, we just had this exact issue on not filing a demand for jury trial in a Butler County case for the lunch hour. Mr. Patterson presented 19 Canap 2nd 982, State of Kansas versus Gardner L. Jones III. Jones raised two issues on appeal: whether the district court abused its discretion by denying his request for jury trial, and whether the district court erred in denying his motion for setting an appeal bond. Well, I have not had time to read that case over the lunch hour, which began at 1 o'clock today because we ran so late this morning. But Mr. Patterson, as an office of the court, informs me that in a case like this, even though the statute of Kansas is very clear that you are to put your demand for jury trial in writing, the case law says you don't have to because of your constitutional right.
I haven't had time to research it or read it, Judge. I don't have any kind of written request or motions, and I would have to take time to also read the case.
Sure.
And see if it's distinguished, if there's different issues.
Mhm.
But he's wanting to argue jurisdiction, dismissal motions, and all kinds of motions. There's nothing before the court in writing for me to respond to. I don't know what he's going to say. So one of our other pro se individuals had written several motions. Most were very lacking, but at least I had something to respond to. In this case, under the laws and Constitution of Kansas, you submit when you come into our jurisdiction. Therefore, when he traveled into Kansas and operated a motor vehicle, he consented to the laws and jurisdiction of Kansas. And I would say that we have jurisdiction, and that lack of venue and jurisdiction is should be denied.
I had a question about that, because when you say that I consent, is there like a form? Would that would that be under? That would be civil. Would
Sir,
that be like
you consented by your conduct of going onto a road that is a state of Kansas highway and a.
So which jurisdiction would be under? Like, would that be like maritime, like as a
Sir,
contract?
I've answered that question to you, and you got on the road and you consented to driving on the road, and therefore you did consent to laws associated with driving. So I am going to hold you to the law in this particular case. Now,
what I'm understanding when you say the cause of nature, and but that's why I was not understanding still about that, because you said the cause of nature, and I asked.
Sir, if you want me to entertain any of your arguments, you need to have them well thought out, and you need to have them in writing, and you need to have them, sir, listen to me, please. You need to have them in writing. You need to have them filed with the court. You need to give copies and notice to Ms. Gillette so she can have an opportunity to respond. And I'm not going to entertain this process throughout the proceedings where you come in and you just start saying things.
I have a question.
Things that you may have picked up here or there on the internet or by other people. I don't know where you get some of this stuff, but it is very common for people, certain individuals, to come in and start repeating some of this stuff that so far I haven't heard anything that has merit. These arguments of, well, you're either maritime or you're common law. That's not going to carry weight with me. You're going to have to give me something that tells me I have to follow those arguments, because I think you're misstating the law. So by now you should have had all your motions on file. We're ready.
Maybe misunderstood what I was asking.
Please don't interrupt me.
That's why I had a question.
Sir,
When you're done.
stop and listen to me. If you want a jury trial, I will make sure you have a jury trial. If you want to
Before I get to that, I
represent,
have
sir,
questions. That's what I said.
stop
Before that.
interrupting me. If you want a jury trial, I will make sure you have a jury trial. If you want an attorney, I'll make sure you have an attorney to help you. But if you're going to do this on your own, you need to know what you're doing and you need to follow the law just as an attorney would be expected to. But you're not going to come in here and just start saying things, and I'll answer questions as long as they're legitimate questions. So at this point, I'll ask you once again, are you sure you don't want an attorney to help you, someone who is trained in the law? Because this, sir, is a court of law. And if you don't have the benefit of knowing the law, you're going to be disadvantaged.
Well, before I move forward, I had questions before I move forward. That's why I was asking to understand it. Because I was trying to understand this.
Well, I can't aid you in the unauthorized practice of law. I cannot.
No, I'm not asking. I'm not asking for legal advice. I'm asking for your legal intent. What am I going to? What do you intend to be trying me with jurisdiction? That's why I'm asking if it's under which one. And you said it's a criminal matter. If it's criminal,
Sir,
there's someone that's been hurt. So if there's someone's been hurt, I have the right to cross-examine.
I have answered your question legally, and you keep trying to give me limited illegal choices, and I'm not going to do that.
Under the Sixth Amendment, I have the right to know. Under the Sixth Amendment, I have the right to know what jury I'm going to be tried against, and you have the duty to tell me. I don't think you're going to be violating your oath to office if you did that.
I've answered those questions, sir. We need to move on. I've made it clear to you, it's a couple of hearings now that you're being tried in the District Court of Greenwood County, Kansas, under the laws of the state of Kansas. And we're not going to keep running in circles on this.
That is not.
You know this, and I know this, and I feel like you're just kind of.
No, what I'm asking, so the court the Constitution only grants the court under when it comes to criminal under two matters, and that's why I asked you: is it civil? Is it civil or is it criminal? What you said is criminal, so it's not civil, right?
Sir, you can reserve your right for appeal, but I have ruled. Now, what's your next question or your next point of view? And I need to have you back here. Bring your camera back so I can see you.
Your phone froze. I don't hear what you said. Your phone froze. You froze.
I don't know if my phone froze or your did.
Oh, my phone froze. You cut out for a second.
Okay, so do you want an attorney? I'll ask you that again.
Before I get to that, I still have to find out. I have the Sixth Amendment right to know. If I ask, I have the right to know. I'm not asking for legal advice. I'm asking for your legal intent.
Do you want a jury trial and do you want a lawyer? Those are the two things.
Before I get to that, I have to understand what jurisdiction I'm under so I can rightfully know how to defend myself.
Okay,
now.
you don't like my ruling.
You don't. So I had to. So are you telling me I have to get a lawyer to understand? For the record, do you just have to get a lawyer to find out what I'm going to be tried against? Is that just some type of secret jurisdiction that I should know about?
Okay, sir. Here's the deal. You're either. I'm not going to play games with you. I understand the sovereign citizen position that you take.
I'm not claiming. I didn't say anything about sovereign anything, ma'am. I'm asking how
the
right to defend myself
under
my Sixth Amendment right to know. I have right to know which jurisdiction are you going to try me under, and you're telling me in order to ask me for a lawyer. And I'm like, before I even go to trial, I like to know what jurisdiction I'm falling up under. And you're telling me how to find. In order to find out, I have to get a lawyer. So you're telling me, for the record, the defendant has to get a lawyer because there's only only lawyers understand what jurisdiction or what I'm going to be tried under. So that's the only way I can know. Instead of you asking me, but you have the duty to tell me under the Sixth Amendment. Do you not?
Okay, now it's your turn to stop talking and my turn to talk. I have answered your questions. I've told you the jurisdiction. You don't like my answers, so you voice your objection for appeal and we move on. We're not going to keep playing this game, sir. Now, do you want a lawyer or do you not?
I need a lawyer for you to tell me. When I'm asking you, because you said it's not in the criminal matter, so there's a hurt party.
Sir, quit repeating yourself.
If there's a hurt party, can you present the hurt party to me?
If you keep sitting here wanting to argue with the court, I may have to find you in contempt. Is that what you're trying to get me?
I'm not arguing about the court. I'm trying to understand. I'm still not understanding.
I cannot educate you and train you.
I'm not asking for educate.
If you want to sir, do you know there's a person that's going to try to type out this transcript? And if you keep talking over me, do you know what chaos you're going to cause for that transcriptionist? We have to take turns talking. I've answered your question repeatedly. Let's move on to the next question. Or the next point. You don't have any motions I can rule on because you don't have anything in the file. So are you going to hire an attorney, apply for court appointed, or continue on your waiver?
So if you're going to try, is there someone that was hurt to make a criminal matter? I'd like to know who it was.
Are you going to hire an attorney, apply for court appointed, or continue to waive your right and represent yourself? Keeping in mind, sir, if you waive your right to an attorney, you will be held to the same standards as a defendant with an attorney. You will be held to the same standards as the attorney. You need to know the same rules, procedures, and laws. So what are you going to do on the issue of attorney? Continue to.
I'm just simply asking you to identify which the code of the written law that you're asking to do. I'm just asking you to which code is that you're bringing against me as constitutional law. Because if that's a civil rights law,
taking up time. Can you not understand what I'm saying?
You're asking me if I want a lawyer. If I want a lawyer, I'm not moving forward because I'm not understanding where we're still going under here. Where you're telling me like it's on the criminal matter. If it's on the criminal, if it makes a criminal matter, that means it has to be like some injured party. Where is injured party at?
I'm going to order that you appear at the courthouse. Where are you parked right now?
I'm in Texas.
You do know your trial is Wednesday and you have to physically be present in the courthouse. It is not a Zoom.
Before we get to trial, I'm trying to figure out the jurisdiction. You haven't went over to me what the jurisdiction is.
Well, if you don't want to submit to the Kansas jurisdiction for your live trial on Wednesday, I can get you a warrant and you can be brought before the court.
I'm appearing in person right now. I'm doing my duty to appear, but you're not telling me.
We're not having a Zoom jury trial.
They're not telling me. You're not telling me you're not even telling me what the nature of the cause. You're not even telling me if it's common law. If it's common law, then you telling me that it's a criminal. If it's criminal, then there should be an injured party. I'm asking, where's the injured party? Can you bring the injured party forward?
I am going to, Missy, do you know where Miss Gillette went?
I don't, Judge. I'm assuming she lost signal.
So, are you not going to tell me his work today? You have the right to know.
Do you want to try to see if you can find her for me, Missy?
I think when she gets signal, she'll be back.
Okay, well, we're going to be in recess till Miss Gillette gets her signal and gets back here because I'm not going to do anything without both parties present. So we're going to go into recess.
Where?
Sorry, Judge, my phone screwed up.
Well, apparently the defendants did too, so I'm gonna give him a few minutes to see if he comes back.
Everything went out and I couldn't get back on at all.
There he is.
Okay.
All right. We are back on the record in the 13th Judicial District, the District Court of Greenwood County, Kansas. Case 2023 TR 3000060. State of Kansas versus Isaiah S. Curvin. Parties as before. Mr. Curvin, you are set for jury trial.
But before we even get
Wednesday.
to trial, man, you still haven't answered my questions. I still want to know
Wednesday,
the cause of
November.
nature of the matter.
Sir, I'm going to find you in contempt if you keep talking over me and being disrespectful.
Ma'am, you keep not even answering my question before we
All
get to jury
right,
trial. You're just
okay.
setting it.
You are now found in contempt.
That's it.
We will deal with your consequences Wednesday at the jury trial. This is set for jury trial. It's going to cost the taxpayers some money, so you better make sure you're ready to go to jury trial come Wednesday. You better make sure you're not in Texas. You better make sure you're sitting in the courtroom in Greenwood County, Kansas. That's Eureka, Kansas. Do you understand, sir? Any questions about?
I don't know. I still have questions that was never answered.
I'm not your attorney, sir. I'm your judge.
Yeah, I know you're not returning. I'm asking you, Judge. I'm asking for legal advice. I asked you what was your legal intent. You still haven't told me what your legal intent. I asked you what was the nature and cause of this.
My legal intent is to conduct a jury trial on you Wednesday with the jury.
And what was the nature and cause of this whole before all that? What was
The
your nature and
nature
cause?
of this charge is that you were allegedly operating a motor vehicle without a license in Greenwood County, Kansas, November 9th, 2023. That's the nature. Now,
And you said it's, and I asked.
We're not doing this.
I said a question. So when I asked you what jurisdiction the court, the Constitution grants the courts the two jurisdictions. Which one is common law, and the other one is maritime admiralty law. You said it's neither one of them.
Sir, you better go back to law school because I don't think you got the education you need to represent yourself. You either need to go back to law school or go to law school or get an attorney, sir, because you don't understand that which you're speaking of. So be ready to go. And if you're not here and ready to go, Wednesday, I will issue a warrant for your arrest.
Your Honor, I still have a question. You still haven't answered my question before you dismiss. I asked you which law.
Sir, I am not
under the Sixth Amendment, right? Under the Sixth Amendment, you have the
Okay, I'm going to fine you. I'm only going to fine you $50 for that first contempt.
$50 for what?
For continuing to ask the same questions over and over after.
I'm asking it. You never answered it. You never told me which.
I'm going to object. It's been asked and answered. It's been ruled on, Judge. We need to proceed to the next step. The state has taken the opportunity to glance through the case Mr. Patterson cited. It can be distinguished from this case because the ruling says the person has to be subjected to up to 12 months imprisonment. It is a DUI case where someone was convicted of a first-time DUI and they were subject to 12 months of prison time or jail time under the law. This is a Class B non-person misdemeanor that's 6 months or less. It must be greater than 6 months in order for the person to be subject to an automatic jury trial. Otherwise, lacking the request, it may be a trial to the bench under the case law. So therefore, the State v. Jones did not apply in this matter. He is facing no more than up to 6 months. So the automatic requirement for jury trial does not apply in this case to Mr. Curvin. The request for jury trial would still need to be in writing for a matter that's up to 6 months. And therefore, I would ask that we don't waste a jury's time and have a bench trial on Wednesday. and move forward in the case.
Mr. Kervin, do you want a jury trial or a bench trial?
I want a jury trial.
Understand, I'm not going to prejudge, but I'll strike that. That wouldn't be appropriate. Missy, do we have tomorrow open? Let's see, we've got a 9 o'clock docket. What do we have going on tomorrow afternoon, Missy?
We have first appearances, and I haven't looked at them yet. And then,
Okay, and then we have 3:30.
yeah, we have a couple at 3:30, and then we have a 4 o'clock case.
Ms. Gillette, can I continue this for further pretrial hearing with the live hearing, defendant present tomorrow at, what do you have? Can you fit me in at what, 2:30, Missy? Do you have time then? Pick me a time. Give me about a half an hour tomorrow that you can fit me in.
I think our 11 o'clock went off. Let me.
I was going to say
Are you saying I have to-
11 o'clock is the perfect time for the state judge.
Well, but I've got to
It's gonna have to be
give Mr.
for
Kervin,
tomorrow.
I've got to give, sir, please quit interrupting. This is not a free-for-all. Ms. Gillette, we've got to give him time to drive up from Texas.
Yeah.
Well, if he doesn't have a license, he can't drive. We have to give him time to find someone who can drive him up here, or give him time for a plane ticket, or however he wants to get here.
1 o'clock p.m. from 1 to 1:30. Then we can start the first appearance docket at 1:30.
Sounds good. Okay. Sir, this is going to be a live pretrial hearing tomorrow at 1 p.m. You must be
I
present.
cannot make it tomorrow, ma'am. I'm in Texas. That's what I was trying to tell you from before.
Well,
You told me you said Wednesday at first, and now you're saying tomorrow.
Well, your jury trial is Wednesday. Your pretrial is continued to 1 p.m. tomorrow. There is no law that says I have to give you a Zoom hearing. I try to do that as a courtesy. In
I
most
could do the
cases,
Zoom, but I wasn't able to drive because this where I'm at, like I'm already like right here by San Antonio. It's like about a 14-hour drive. Like even if I like drove right now, I would still wouldn't make it to like probably 2, and I would like drive like this like 32, 14. That's like half the day driving. Now I don't have nobody to drive like that. You know, man. Like that's why like.
If you don't have a license, you better not be driving, because then that'll be another violation of the law. But that's my order. Be here at 1 o'clock tomorrow. Live and in person. If you're not here, then most likely a warrant would issue for your arrest, and we'd go from there.
Well, I'm telling you, if I wouldn't make it, what's my other option? If I'm already in Texas, not to, that's hours away. You know, it's like about 4 different states.
Well, sir, you came to Kansas. You violated the laws allegedly in Kansas, and you've taken up a lot of the court and counsel's time. So,
well, I was told the officer said he told me I can take care of it from Texas. I will have to come back to Kansas when I got the rest of the ticket.
I have always told you that the trial would be live. Don't be pulling that on me.
No, not you. I'm talking about the officer when I got the ticket. When I first got it, I let him know like I was just coming through Kansas. Like you don't live here. He said normally it's to do videos and stuff because it's like different state.
Normally it is, but I'm ordering that you be here in person tomorrow at 1 o'clock. And anything further, Ms. Gillette?
Nothing at this time.
Hold on, my phone cut out. Hold on. So,
Mr. Kervin?
say it again, ma'am.
Any motions you want to take up tomorrow at the pretrial, you better have them filed by 5 o'clock tonight with copies served on the prosecutor, or I'm not going to entertain them tomorrow. You've had a long time to get those on file, and you haven't done it. And I'm through with repeating myself over and over. So at this time, you owe the court $50 for contempt. We'll address that tomorrow as well. Okay, we'll begin recess.
Thank you,
Judge. Before we go, when you said like how to file the motions and everything, did you receive my special appearance motion or anything like that?
Nope. No, sir.
You hadn't received it from last time?
Nope.
I filed that before.
No, sir, I don't know what you're doing with them, but we're not getting them here.
I was told that you had received them through email, or I sent the email
Okay,
to I sent it a
sir.
few times. Not like that was the only what.
If you can't figure out how to do it on your own, then you need an attorney. And I have told you repeatedly that if you cannot afford an attorney, you can
No, they
appoint
told me.
one, and I will appoint one.
They told me they had received them before. That's why I was understanding. Like now you say you never received them, but you say you received them before. Like the first time we appeared, and then I actually I haven't received them. I haven't called.
Irvin, just because you keep repeating something doesn't mean you're going to get a different result.
No, I haven't repeated. I'm asking like they never received it, but they told me they did. That's just
You keep saying the things over and over, thinking like you're going to get a different result, and the answer is going to be the same every time.
You have a good day, Your Honor.
Thank you, sir. We are adjourned.
Thank you, Judge.